hopefully. Okay, so thanks for listening to that. So, and apologies that that lady was talking very quickly and there was a lot of information to take in, but I've taken out the 6 or 7 basic points. And for those of you, a couple of people were just a little bit later than some of us joining the call. We'd already started. But just to let you know very quickly, what we're going to talk about now is what constitutes a contract. And it obviously affects all of us in our daily lives. And then we're going to talk a little bit about international contracts. And then we're going to talk about a little bit about the internet and the consequence of the internet on international contracts. The real overriding theme being we're responsible for whatever we sign for, basically. So just in terms of that, before we go through this slide, I just want to recap what we talked about there, the formation of a contract. So if you've got your pen handy, if you didn't catch it from the way that lady was speaking very, very quickly, we've already agreed that a contract of sale is whereby a seller transfers or agrees to transfer a property for a buyer to the price. So what really makes up a contract is an offer of service or product, the acceptance of the offer, and a consideration, that being the price. So those are the 3 main things. What am I going to give you? What are you going to give me? And how much are we going to pay for that? What is going to exchange? Whether that could be goods or obviously in most cases it's money. But that's essentially what constitutes the contract, the nature of the contract. But then we have the written contract itself. And whatever industry you work in, maybe have a look at contracts tomorrow that your organization works with. Because certainly in the organizations that I've worked with, we follow this every time. What I picked up from this, and have your pens handy, was the contract needs to be called a sales contract. We need to explain what the agreement is. Contract of sale in many respects. Sales contract, sales agreement, whatever it might be, but it needs a name, it needs a heading. That's number 1. Number 2, the second point is every party involved in the contract needs to be named. So there's no point in having a contract if we don't say on that contract who the contract is between. So Joe Bloggs and Janine Bloggs, whoever, need to be named in that contract with as much information as possible. You know, for example, there's no point in putting my name if you don't really put my address and my contact, because there are a number of Martin Nicholses around. So the contract could be through somebody, but if my telephone number's on it, my email address is on it, and my name's on it, I am identifiable to that contract. So normally it will have 2 business entity names as well, or the address or whatever it might be. And this, I would say, becomes more and more important as we go internationally and as we start dealing with businesses overseas. Because obviously contracts are more difficult to control the further they are away from home. Okay, number 3, description. So number 1, name, sales contract. Number 2, define every party. Number 3, a description of what the service is or what the product is. Number 4, guarantees. What guarantees are we going to offer? And what price are we going to charge, pay, whichever way you look at it. So already, as I said before, we've got the offer. We've also got what one party is going to give and what the other party is going to give. So what each party is going to give and take, with a description of the service. Then we have penalties, as she mentioned, to make sure there's a proper exchange of value. And I think also one of the most important things is subject to the laws of. I ran companies in Singapore, Australia, and wherever they might be, working across the region. But for example, when I ran a company in Singapore, although I was working pretty much across the region, a global contract or a regional contract would generally be associated or administered under the legal jurisdiction of Singapore. Maybe our 2 head offices were in Singapore, or if it was a one-off, purely in Indonesia, it would be between my office in Indonesia or an Indonesian client, or Australia and Australia, or whatever it might be. But for regional stuff, it was generally the headquarters. But it's very, very important because that's where we can come into problems. She mentioned signatures, and it seems very obvious, but I can't tell you how many times I've seen agreements sent to a client in principle agreeing, and that, you know, you sell something, you say, oh yeah, we'll charge you 19% or whatever it might be. The contract goes to the client, the work starts, yet both parties have not signed a contract. Or the scenario is often the case where the supplier will send the signed contracts. The supplier will send a contract to the buyer, and perhaps they haven't signed it because it could be still draft, but then the buyer signs it, sends it back to the supplier, and the supplier just puts it in a drawer. But unless it's a two-way agreement, it's not going to be relevant in a court of law. So that's one of the things to think about. And also print it off. Seems obvious again, but it's amazing the amount of people that don't. You know, if my computer had crashed this morning, well, I'd have had problems finding this presentation. Similarly, with a contract that doesn't exist, or, you know, you change your computer, whatever it might be, always have a hard copy. So just to recap, name of the sales contract, number 1. Number 2, name every contract. Sorry, name every party. Number 3, a description. Number 4, guarantee. What happens if we don't provide? Number 5, price. Number 6, subject to the laws of. Number 7, signatures. And after that, make sure you print it off. Otherwise, you're going to have a few problems. So is that clear? Are there any questions after that before we move on? Okay. I just want you to remember that a contract is a legally enforceable promise. It's nothing more than that, but that means a lot. It's a legally enforceable promise. A contract of sale of goods is a contract where the seller transfers or agrees to transfer property and goods for the buyer at a price. Such a contract of sale may be absolute or conditional. Absolute contract is without any conditions. The conditions may have to be fulfilled by the seller or by the buyer. A common example of a conditional contract is on a buyer getting planning permission. For example, an absolute contract could be the house already exists, and obviously subject to transfer of ownership and all that type of thing. You're buying something. If you buy off a printer, then you're generally going to walk into a shop and buy the printer. There's an inferred contract of sale and you buy the printer. But it could be conditional on the fact that if you buy, if it's a perhaps a large construction project or a project to make some specific machinery or whatever it might be for you, then we will call that conditional. So it's also important to understand, as a result of that, when the product actually changes hands. So where under the contract of sale of property and goods is preferred for the seller to the buyer, the contract is called a sale. But where the transfer of the property in the goods is to take place at a future time, i.e.